Hello everyone, welcome to Legal Discussions. The topic today is ADR. This is the topic of our discussion, and it's not supposed to be a very comprehensive topic. Rather, it is a very comprehensible discussion in a very small framework just to provide the viewers with the understanding and basic, very basic framework of ADR. So, let's get into it. ADR. ADR stands for Alternate Dispute Resolution. Now, one must see that it highlights three things: alternate, dispute, and resolution. Alternative to what? What sort of resolutions, etc. Now, let's take a look. ADR basically means alternate dispute resolutions. So, basically, there is a court litigation and then there is ADR, alternate dispute resolutions. So, essentially, it's when parties first try to resolve the dispute themselves, try other things, like for example, getting a third party involved to the dispute to help them resolve the dispute, and the final litigation. As always, as Jackson stresses in his handbook, Jackson's ADR, by several authors, ADR is preferred over litigation, and litigation should always be used as a last resort. Now, in this lecture, we'll be taking a look at types of ADRs, advantages, and also some disadvantages later on in the discussion. And we will be also analyzing what types of ADR and what essentially different ranges of ADR there exist, such as its types, such as adjudicative or non-judicative ADRs. Let's discuss the type of ADRs first. You have your arbitration, mediation, negotiation, conciliation or reconciliation, expert determination, and early neutral evaluation. These are essentially six types of ADR. Now, mostly I will be comparing or giving you a brief outlook on how ADR actually works in Pakistan, but this lecture itself, or this discussion itself rather, sorry, can also be interpreted to different parts of the world. So, arbitration, mediation, negotiation, conciliation or reconciliation, expert determination, and early neutral evaluations. We'll be covering each of these up ahead in the lectures ahead, so please look out for those. But first, let's discuss why should ADR or alternate dispute resolution be used instead of a litigation process or going to court, essentially. The most common thing, as per people say, I'm going to see you in court. So why give up that sort of legal threat in favor of ADR? Well, ADR is a very simple and easy thing to understand, and it's not supposed to be complicated at all. Hence, the purpose of this discussion is to make ADR simple for the for lawyers and people who aren't lawyers alike. So the first advantage of ADR is obviously lower cost. Saving money, that means essentially. So litigation is expensive for the most part, and ADR being an alternative to that litigation, it saves plenty of money because, simply put, as we have previously seen in the types of ADR, you have negotiations which can basically cost no money to negotiate between the parties. You can take your lawyer or you can take your representative or counsel to these negotiation meetings, and that will spend some money but not all, because negotiation is considered a few hours. Similar thing for arbitration, mostly resolved very early on in the process, and hence save costs. The next factor is being speedy. ADR is a very speedy process. Negotiation can take only a few minutes to few hours depending on the nature of the dispute or the subject matter. For instance, if we consider negotiation and we go to a simple shopkeeper to buy, let's say, a can of soda or a can of soft drink, it merely takes 2 to 3 minutes to select the soft drink, pay, and then get out of the store. That is essentially a form of negotiation as well. So it's very speedy. It saves money because it saves time, and it's very speedy process per se. Then you have choice of forums. So from arbitration, mediation, conciliation, reconciliation, uh, early neutral evaluation, expert determination, there are wide range and vast choices available to a party. So the party can itself have control over the choice of the forums they wish to use. For example, a simple dispute upon a notebook, let's say for instance, or a diary, can be easily resolved with negotiation or mediation, while complex disputes of, let's say, property based and complex natures in terms of evaluation, they can always be recommended to our expert determination, arbitration, etc., etc. Because of the choice, the parties generally tend to have more flexibility and control of the process itself. Now, in litigation, the parties tend to have very limited control. It is their counsel or advocate or lawyer in terms of arguing, and then the parties merely just stand by or come and give their evidences when they're called upon by the court to do so. In that regard, court issues summons and whatnot. In terms of the processes of ADR, while negotiation is extremely flexible, and you can basically, there can be a negotiation on a cup of tea, for example, and things like that. Or same, taking the example of the shopkeeper and buying a can of soft drink, it is very flexible, and the parties can decide upon the method they choose to pay upon and different aspects of it. So generally, it has more flexibility from the price, from the way of payment, from the way they wish to resolve the dispute, place where they wish to resolve the dispute, and several other things, if not all of these. In terms of the control of the process, the parties in negotiation, mediation, even conciliation, expert determination, and to some extent early neutral evaluation tend to control the processes from start to finish for the most part, while mediator, arbitrator, or conciliator might be able to control and set meeting timetables and schedules. They normally do not tend to completely control the process. So parties do have a certain degree of control in these proceedings. Mind you, when I say proceedings, I do not mean uh, litigation. I of course mean I of course or I mean just general degree of control and a general degree of a process that happens during the ADR or proceedings. Let's discuss confidentiality. Confidentiality. For sometimes the parties are very interested between amongst themselves is the principle of confidentiality. So, for example, let's say um, there tends to be a dispute of high-profile case. For example, let's say amongst the celebrities, and instead of making it a bait for paparazzis and feeding the paparazzis, what they can normally do is they can uh, go for ADR either through mediation or conciliation or personally negotiations as well. If negotiations do not happen, they can go for these types of processes, and like, this is a common notion that court is a place of public domain. Anyone can come and witness the proceedings, watch the proceedings, etc., etc. Confidentiality in ADR is very different. In a room of in a room where there is mediation taking place, you will have mediator, the parties, and most likely they're either solicitors or barristers or lawyers to some other countries. So not a lot of parties. There's no press people, there's no reporting people, there is no general public. There is merely the staff and the mediator itself. So another aspect is the non-prejudicial effect. So if the parties try an ADR, it doesn't work. The parties see no point in continuing with the ADR. They can move to litigation, and when they do move to litigation, every communication, every thing said or done inside the proceeding of an ADR, for the most part, mediation, conciliation, reconciliation, negotiation, early neutral evaluation, or expert determination, everything said and done in the ADR will not be repeated before the court or would be quoted before the court. Then we have future relationships, such as securing future relationships. For example, take a simple dispute between two partners, right? Husband and wife, girlfriend and boyfriend, right? Future relationships are if it's a very key factor for them to maintaining ADR, right? for example, the wellness of their young ones or their children may be at stake, right? Mental well-being, then they can easily secure that by doing an ADR, right? So they can easily go for negotiation. If that doesn't work, move on to mediation. Doesn't work, help, take the help or enlist the help of a conciliator, so on and so forth. So if the future relationship is a very key aspect of resolving this dispute or the dispute, then ADR is a perfect choice, right? Because in litigation, again, litigation can come with the cost of the relationships. Things do tend to get pretty heated in the courtrooms. As I'm not talking about in a way of like things do get to be things become out of control in terms of future relationships. What I am saying is that things do take a turn for the worse in litigations for the most part. So ADR is a very friendly and approaching way to solve and preserve and help the parties preserve the relationships. Then we have no formality, or as it's usually taught in the UK bar course, it's no wigs and gowns approach. So there is basically no formality as in how things will go in terms of whether you're supposed to wear suits or no suits or gowns or wigs and no gowns. Obviously, you're going to be expected to maintain a certain level of etiquette. That does not mean you come inside the ADR or like mediation in your PJs or pajamas. It definitely does not mean that you're supposed to wear the suit and everything with the black tie as a lawyer would and stuff like that. Or just general etiquette implies here, just general moral etiquette. So no wigs and gowns approach, no formality. So the parties, if there is like in litigation, the aspect of formality to some extent seems to threaten or seem to uh, leave an impression upon the parties themselves selves that they don't have control. There's formality going on. They themselves feel very shy and nervous in terms of participation, and they can't really participate in terms of litigation unless again and say unless, and there is a general rule that they're called upon by the court to do so. So in that regard, in terms of formality aspects, in terms of clothing, there's no formality. The language is not supposed to be the legal language. It's very simple, brief, understanding language. Anyone is easily able to understand, etc., etc. So there is basically no wigs and gowns approach, as per Jackson's ADR and generally as well. Right. So there is no hard and fast rules of evidence. So there hard and fast rules of evidence. Now this is the new edition that I implemented here. Generally speaking, so let's talk about Pakistan for a minute. In litigation, one must abide by the Qanun-e-Shahadat Order 1984. So in Pakistan, that would generally be more applicable. That would be, sorry, that not applicable, but rather that is the more used form of uh, Evidence Act. There is no Evidence Act. There used to be an Evidence Act. It was replaced in 1984 by QSO. So because of that, the way or the method of delivering evidence or bringing the evidence before the court is actually very, very flexible, right? There is a certain process that takes place during litigation. So generally speaking, in Pakistan, the in a civil matter, the trial goes something like this: that there is plaintiff witness number one, two, three, four, etc. up till infinity, and then you have the plaintiff's statement then itself and the evidence of plaintiff, cross-examination, so on. Then comes the defense side, so DW1 to DW infinity, and then you have the defense statement, then you have closing arguments, and etc. etc. This is a general framework, not exactly accurate, but just for general understanding. In ADR, there's no hard and fast rules of evidence. None of these matter. If you want, the defendant can on statement give their own what their version of the story is. The plaintiff can give their version of the story, so the parties can basically intertwine. Secondly, in terms of bringing exhibits in the court, there is a particular way. So either the parties will bring it, the original documents, or the representative of an institution will bring it. In terms of ADR, there is no hard and fast rule. Anyone can bring that evidence. Most of the times, the originals are not even considered, but even if they are considered, are meant to be very, very important, such as a lease deed or a sales agreement. They are brought in by either parties, which are very easy to implement as compared to in terms of litigation. So there's no rules, no hard and fast rules for evidence. There are some rules, but not as hard and fast that are going to be litigation. So that is the general consensus of ADR. So some more info, as I've discussed earlier, there are two ranges of ADR: adjudicative types of ADR and the non-adjudicative types. Adjudicative types mean essentially where the decision is mostly binding upon the parties. The types that are adjudicative of ADR are arbitration through an award or expert determination, depending on the type that will be binding or non-binding upon the parties. In terms of non-adjudicative aspects or non-binding decisions, you have negotiation. So uh, anything the parties say in negotiation will not be binding upon either parties unless they have made a contract to do so. A contract, in again contrasting this, a contract may be enforceable depending on several factors, whether the if it's made on a stamp paper, whether the stamp paper is registered or not, uh, whether there are witnesses to it or not. In terms of legal aspect, you have to take a look at QSO, Article 17, and so on to see whether the contract is binding. But generally, negotiations and what's said and done, verbal communication, mostly and likely is not binding or is non-binding. Mediation, same principle. Mediation is essentially negotiations with the help of where if the things get heated, mediator comes in and tries to calm them down. Negotiation, mediation have very tiny bit of differences. That mediator is there just there to control the temperament of the parties and maintain a discipline. Same thing for conciliation is also non-binding decision. Early neutral evaluation, while not extensively practiced in Pakistan, still not a is still a non-adjudicative type of ADR. So, before we conclude, um, I would also like to highlight some of the disadvantages of ADR, which are not available in these slides, unfortunately. So, the most critical um, disadvantages or where parties should go to litigation and avoid ADR completely, because in Pakistan, generally speaking, there is no um, rule that you must go to ADR first. The courts most likely would not even consider, and so on. So generally speaking, in terms of the ADR and why when parties should prefer litigation over it, one scenario would essentially be where the rules of evidence are very important, right? Number two, where all types of ADR would generally fail. So, for example, parties don't see any point. They do not agree to an arbitration agreement, or do not would never agree to an arbitration award. They hate each other super extensively. Expert determination would not help the case because there's no issue of expert determination to be determined upon. Things are very simple and clear cut. Um, that does not tend to normally be the case. Negotiations where the parties again hate each other, they would not be sitting with each other in terms of mediation. Mediator would not resolve it, conciliator would not solve it, and E&E does not exist. So in Pakistan, in UK, E&E exists, but where the parties will go to litigation regardless because of either inbound hatred or inbound envy nature of the case, where it's rather a bed of thorns to go into ADR and waste the time and the money that would be spent on ADR could and achieve nothing, but rather go to litigation directly. So those scenarios where evidences are very important and they need to be taken, and then there is an important topic of appreciation of evidence, that evidence should be examined and cross-examined depending upon who gives it, and so on, and evidence needs to be controlled according to the court, etc., etc. Those are few of the scenarios where ADR would never be appropriate. Now, the reasons I have not introduced this in this discussion is because um, authors tend to generally disagree amongst themselves. Academic scholars do not really agree with each other in terms of uh, some say that there are disadvantages or there are scenarios. Obviously, there are going to be scenarios, but they say they are not, like, they do not tend to agree on disadvantages between disadvantages of ADR itself. Rather, they tend to say that okay, ADR should be tried and then moved on to litigation if the ADR fails or alternate dispute resolution fails. So that is generally a brief overlook of ADR. Thank you so much for watching, guys, um, and listening to the discussion, wherever you may be. Again, please do your own research to understand a further comprehensive understanding of ADR. I will be uploading hopefully some discussion, sorry, in the upcoming um, few weeks, I guess, to give a better understanding of ADR. But this was a general lecture for the entire, I would say pretty much it's applicable everywhere. The next few discussions on arbitration, particularly because arbitration is mostly statutory based, so they will be for people that are specifically living within Pakistan. That is more of an academic topic, while this being just a general discussion. Thank you so much. I hope you have fun. I hope I made ADR a little bit less complicated. And thank you so much for watching.